You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Wills and Probate podcast. Today we're chatting about a recent case, Leonard and Leonard, and the circumstances surrounding a claim and the implications, I suppose, for practitioners around the interpretation of Banks and Goodfellow and why it was important in this particular case. Not a topic I am particularly well qualified to speak on, but I have Bernadette Baker and Kate Harris on the podcast to explain more. Bernadette is the head of private wealth dispute team at Birketts, and Kate Harris is also a partner in that team as well. It's lovely to have you both on the podcast. Thanks very much indeed for joining.
It's lovely to be here.
In the first instance, perhaps you might tell me about yourselves. Bernadette first, can you tell me about your role in the business and a bit about your background, please?
Certainly. Yeah, as you say, my name is Bernadette Baker and I head the private wealth disputes team here at Birketts. I've specialised in contentious probate and trust disputes for over 15 years now, and I've been at Birketts since I qualified, so I've had my 20-year anniversary here. My practice involves advising clients on all manner of complex legal issues relating to wills, trusts and estates, including inheritance tax claims, will validity challenges, arguments relating to capacity issues and undue influence, as well as any issues arising from executors breaching their duties or the interpretation of complex will provisions. In addition, the team has experience across the full range of trust issues, whether they're involving a trust instrument or implied or constructive trust situations.
Super useful. Thanks so much, Bernadette. Kate.
So I, similarly to Bernadette, I specialise in all of the topics that Bernadette's just mentioned and have been doing so for a similar length of time. So I am not a lifer with Birketts. I've worked at a number of different firms, but have been at Birketts now for coming up to around 4 years, and I'm a partner in the team. As Bernadette says, we cover the kind of broad spectrum of succession disputes, anything to do with contentious trusts and probate matters.
Well, we'll dive right into the topic at hand today, which is Leonard versus Leonard, a probate dispute between children and a second wife and the father. You will explain it an awful lot better than myself, Bernadette. Can you give us some context around Leonard and Leonard? What was the case about?
Certainly. The case of Leonard and Leonard centred on the will of Dr. Jack Leonard. Jack was a very successful entrepreneurial engineer. He set up his own company known as Eurotherm back in the 60s, and it floated in about 1978, which ensured that Jack became a very wealthy man. Jack had met his first wife, Audrey, back in the 50s when they were at university together, and she'd worked tirelessly alongside him to build the family business and their accumulated wealth. Between them, Jack and Audrey had 4 children who subsequently became our clients: Jonathan, Andrew, Sarah and Megan. Very sadly, shortly after Jack retired, Audrey was diagnosed with terminal cancer, and after a very short illness, during which Jack went to great lengths to ensure she received the best care possible, she died in 1998, leaving her entire estate to Jack, which had a value of about circa 1.7 million. Jack was understandably heartbroken after Audrey died, and he began looking for companionship and met his second wife, Margaret, not long after Audrey had died. Margaret was also a widow with 3 adult children from her previous marriage, Mark, Elizabeth and Melanie. It was never disputed between the parties in this case that Jack and Margaret had had anything other than a good second marriage. They enjoyed the lifestyle that Jack was able to provide them with. He was a qualified helicopter pilot, and I think from memory, on their very first date, he picked her up in his helicopter. So ever the romantic and able to sweep her off her feet. They travelled extensively and they enjoyed a life, both being aware, having been widowed relatively young, that life can be fragile and fleeting. Jack's significant wealth enabled him to make diverse financial investments during his retirement, but he having been a professional himself, was quite happy to rely heavily on private advisors to provide appropriate advice for him. Towards the end of 2006, having been married to Margaret for over 7 years, Jack began exploring making a new will to make sure that she was properly provided for. It took Jack a little while to be comfortable with the provisions he wanted to make, but by August 2007, he executed a new will, satisfied that it reflected his wishes. The executors of the 2007 professionally prepared will were his eldest daughter Sarah and his much-loved nephew Robert. Now, the key provisions of the 2007 will were that all of his interest in the home he shared with Margaret, a large property, was to pass to her together with the chattels outright. Shares in a small company holding Jack's interest in a pub he'd run with Meghan were to pass to the party later described as the Leonard children in equal shares. And Andrew, his son, was given an option to buy a property in the States that Jack owned, but which Andrew had lived in for much of his adult life. Jack provided a lifetime right to occupy a property in Findon to his niece, after which it was to pass to Sarah, and the remainder of his net estate was to be divided equally between Margaret and only the Leonard children, with a hotchpot to Sarah of about 100,000. So the principal wealth was being divided 5 ways: 4/5 to the Leonard children and 1/5 to his second wife, Margaret. By 2012, Jack was spending more time with his private wealth advisors as his affairs got more complex, and as he became older, he was looking at tax mitigation planning in detail. In 2013, he was referred to a legal advisor to look at the options available to him, and over the course of the following 2 years, he met with her only twice, but there were a number of draft wills that went into circulation, each growing ever more complex. In 2015, he signed a new will, not professionally witnessed. It was witnessed in the presence of his step-granddaughter's partner and his gardener. The 2015 will differed significantly from the 2007 will in that everything went into a life interest trust for Margaret, still with outright gifts of the matrimonial home and chattels. But upon Margaret's death, the wealth was to be divided 7 ways. 1/7 to each of his 4 children, and then 1/7 to each of Margaret's 3 children. Additional substantiated hotchpots were also taken into account: 200,000 to Sarah and 100,000 to Meghan. Importantly, Jack also provided that whilst Andrew, his son in America, would still have a right to purchase the home he was living in, he failed to recognise that absence any inheritance, as at Dad's date of death, that Andrew would have no monies with which to exercise that option, in effect making himself homeless. In March 2016, Jack received a final diagnosis of vascular dementia, although he'd been exhibiting symptoms for many months prior to diagnosis. He died in March 2019, leaving an estate worth in excess of £5 million. But the net effect of the 2015 will was that most of the wealth ended up with his second wife's family as opposed to his children. The Leonard children were adamant from the outset that a decision to provide for Margaret and her family at the expense of his own children, which included making his youngest son homeless, was so entirely out of character that he couldn't possibly have had capacity at the time he executed the 2015 will, nor could he have known and approved of its contents. This position was accepted by Lady Joanna Smith when judgment was handed down earlier this year.
A really comprehensive overview of the case. Thank you so much, Bernadette. Thinking about the implications then for practitioners, Kate, what were the key takeaways, particularly around the case and the judgment?
So I think, as probably a lot of listeners will be aware, because this case featured quite heavily both in the Daily Mail and in kind of professional publications, the judge found, so Lady Joanna Smith found, that the 2015 will was not valid because Jack lacked testamentary capacity and did not know and approve of its content. So our clients were successful in their claim. But I think probably what's been really interesting and helpful is some of the analysis and clarification that the judge gave in her rather lengthy judgment. So we won't criticize anyone for not having read the entire thing, because it is quite a beast. But we just thought it might be useful to touch on some of the things she mentioned, to kind of give a bit of background, a bit of explanation as to why those are key takeaways, if you like, for people that practice in our area. The first one I wanted to touch on was the Banks and Goodfellow case, which I expect most people will be kind of familiar with how that works and what it says. But I suppose firstly, it's useful to note that this case confirmed that Banks and Goodfellow is still the correct test for assessing validity of a will on the grounds of testamentary capacity. So it hasn't been replaced by the Mental Capacity Act 2005, which, there's been quite a lot of judicial discussion about whether that is the case, but it's confirmed. Banks and Goodfellow remains good law. And obviously it has 4 limbs to it, which people will be aware of. And the Leonard case touched on the first limb, which is that the testator has to be able to understand the nature of making a will and its effects. And this case was also important for the application of the 4th limb, which is that the testator has to not be suffering from any disorder of the mind that perverts their sense of right or prevents the exercise of what's described as their natural faculties when disposing of their property by the will. Just touching on the first limb, what the judge was really wanted to make clear is that it's that limb must be applied by reference to the actual will that the testator is making. So it is not a general application that the testator simply has to understand the nature of making a will. The testator has to understand the nature of the will that they are making. So as Bernadette's touched upon, the will that Jack made in 2015 was not straightforward. It was complex. There were a lot of people involved. There was an American property. As Bernadette's mentioned, that there was a clause in the 2015 will which purported to relate to the American property, but actually didn't make any sense within the context of other things that were going on. So that's the first kind of key takeaway, if you like, is the fact that that first limb, you have to look at how complex the actual will is that the testator is making. And in this case, by the time it had gone through its various iterations, the will that Jack was making or being asked to sign was so complex that he wasn't able to understand what he was doing. Jumping to the 4th limb, what this case really confirmed was that long-lasting illnesses such as dementia can make a testator lack testamentary capacity, whereas previously there's been some debate about whether the 4th limb really is isolated to kind of short episodic delusions, which feature in a lot of the case law around this area. But this case, the judge was quite clear that dementia could cause a testator to fail the 4th limb. So that's really helpful in itself. And, we expect this case to be kind of referred to and quoted, I think, by judges going forward when they're looking at, particularly at that fourth limb. And I think that probably leads on quite nicely to a point about expert evidence, which was actually the judge was quite interested in expert evidence in this case. She was very interested in the way that medical experts in probate cases, in capacity cases, what their role is in the trial, so how they can assist the court. Interestingly, what she found was that those expert evidence, they do continue to have a very key role to play, but that role is limited, if you like, to providing assistance to the court. So the only evidence they can provide is medical. It's the judge's job to apply the law to a medical interpretation, if you like, or a medical opinion on the documents or the evidence available. So I think that's important for practitioners, because it reminds us that even if we get a medical report from an expert that is favourable to our client's case, that is not necessarily going to be a kind of golden bullet. And it's quite possible that a judge may, make factual findings that undermine the assumptions or the expert medical opinion that you may have. And I think it's probably fair to say that was not a surprise, but it was an interesting topic of discussion at the trial itself, because the judge was very clear on that point. I think coming from quite a kind of technology background, she was very interested in the role of the expert evidence, and that comes out in her judgment as well.
I think that point about medical evidence is really interesting. Listeners to today's Wills and Probate podcast may be aware that we have a sister publication, Today's Family Lawyer. We also have a podcast there, and in the not too distant past, we've done a podcast about drug and alcohol testing, and some recent cases there that have had an impact on case law and interpretation, where the judge has said the results are not the be all and end all, and in fact there are certain circumstances that can actually create issues with some of those results as well, but that drug and alcohol testing should not be considered a silver bullet or a golden bullet, as you say, similar to this scenario, but that they should be considered in the round of the context of the case as well.
I mean, it's really interesting, and it's obviously a topic that I'm sure we haven't seen the last of it, and I'm sure that it's a discussion that is going to continue and probably be the topic of quite a lot of hot debate as things go on. That segues quite neatly into one of the other issues, or lessons that came up in this case, which actually relates to the disclosure process and disclosure of documents. And this was, in fact, although we didn't realise, I think, necessarily until as the case develops, it became more apparent, but this was actually a very, very document heavy case, which is something that perhaps is not necessarily always the case, where you have claims which generally are being made by individuals against other individuals. So there aren't corporates. You don't generally expect to have a lot of company documents, that sort of thing. And I think it's fair to say that in this case, the amount of disclosure, the amount of relevant documents we had far outweighed what any party thought was going to be the case. It's a good topic to pause at, because there were so many documents. There had to be quite a careful consideration given to what the experts were going to look at, and what were the most relevant documents for both the experts and also for the judge to look at, and for the respective parties to rely on. And I think one thing that we have taken away, and which I think other practitioners will find useful, hopefully, is that we can't assume that just because a claim is being made by individuals against other individuals, that there aren't going to be a significant number of documents. And we also need to understand and appreciate that with technology becoming more and more of a consideration, and people having computers, iPads, iPhones, storing their documents electronically rather than in hard copy, as might historically have been the case, that very serious consideration needs to be given to how those documents are going to be preserved, and how they are going to be collected together, and how they are going to be filtered. For example, one issue that came up in this case was gaining access to email addresses and to electronic devices such as an iPhone, which, if you don't have the passwords, is actually an incredibly difficult process, which is reassuring in a way. But email addresses and iPhones in particular are locked down quite, and they are impenetrable if you do not have the passwords, and the deceased is obviously no longer around. It does highlight that very, very serious consideration needs to be given to how documents that might relate to a probate dispute or a trust dispute are going to be preserved and are going to be managed if litigation arises.
And Kate makes an interesting point there, particularly with the application of smartphone information going forward. I mean, when you are dealing with any kind of probate claim, you are retrospectively creating a timeline. You're trying to go back to a point in time to see what was going on a specific date. And I think if I apply that to my children who are in their teen years, and they don't seem to be able to go a day without taking at least 100 photographs of themselves, you can foresee situations in years to come, not that many years, where you will be looking at what photographs were taken on or around a date in question, so you can start saying, oh well, clearly they were at that house, or here's a photograph of the party. How did they look? Videos are taken all the time now, aren't they? Because it's so easy. And that started to come out in this trial for the first time that I've really had experience of it, where you are looking at points in time that are captured on mobile devices. And as Kate said, trying to access it was impossible actually in relation to the deceased iPhone. We all formed the view, so this was all of the parties, that actually there probably was a wealth of information on Jack's iPhone that would have been helpful for everybody to see, but nobody had the passwords. He was an intelligent man, so was clearly capable of understanding all risks that we all understand in relation to phishing and things like that. So it wasn't, his mother's maiden name or his eldest child's date of birth. They were sort of sophisticated questions and no doubt sophisticated answers. And even the people who knew Jack very well, and we all between us had a good go at guessing at what the answers would be, but to no effect. We even made inquiries with Apple and other technology-based companies as to whether or not that we could gain access. And there are limited ways of doing it, but they are fearfully expensive and not very successful most of the time. So I think it's one of the things that people do need to think about is actually how are we going to access data held on mobile phones and tablets at the outset of a dispute, and then to get comfortable with whether or not that's even possible.
That's absolutely fascinating, because there's a huge discussion happening in and around this space about digital legacies, how you pass on your information, how you share your iCloud or your Google Photos or whatever it might be, but actually accessing that information for the purposes of disputes suddenly becomes really very difficult. And I'm intrigued that you've not really had a huge amount of success with Apple, who or any of the others for that matter. There are others, of course, that exist out there who have had a similar attitude towards access to digital legacies. I mean, some platforms now have the ability to forget people, don't they, or delete their profile, but you still seem to struggle to access that information.
Yeah, and I think that's something that I think surely has got to develop, because it is as Bernadette says, there's a huge amount of information that could potentially be lost, that may well be incredibly relevant. I mean, I think the other thing that really came up in this case, which again links to the way in which we are holding documents now in an electronic nature, is the preservation of metadata, which I do not profess to be an expert on, but I think we certainly had a bit of a baptism of fire in this case, in that there were certain documents that became apparent at a very late stage, actually, in this case, for various reasons. Some of the key findings, if you like, the key arguments that were run by the parties hinged on the metadata of these documents and when they were prepared and where they were prepared and who they were prepared by. There was a lot of discussion about kind of how this metadata can be changed, so transferring documents from one device to another, forwarding documents to yourself, saving documents, all that sort of thing, which again I think is going to be a hot topic of conversation in the kind of professional sphere, because it can be hugely relevant, especially when we are looking at things like probate disputes and drafting of wills, drafting of will instructions, which is what we had in this case, and who was doing that. If you can quite obviously see a case, if you're looking at, which we weren't looking at in this case, but if you're looking at, say, potentially kind of undue influence case, if you've got a document that was prepared by, and you can show that there's a document that contains will instructions that was prepared by a third party, and the metadata is what confirms that, that's going to be a hugely relevant document. And so this was a case which, while it might not have been kind of hugely central to the judgment itself, it was very relevant within the proceedings and within the litigation.
And that's an important point for practitioners to bear in mind, because we all experience clients who say, okay, yeah, I've got the laptop, I'm going to forward you all the emails I found on it, and explaining to your clients, and no, just don't touch anything, because just by the very nature of forwarding a document that you found that you think is helpful onto us can completely corrupt the metadata and look like it's been created on a different date, or certainly that it's been tampered with, which it 9 times out of 10 has not been, but it just creates arguments and then inevitably additional costs, which everyone would benefit from being avoided.
Two things come to mind as we're chatting. The first is the importance of record keeping. So if you as a firm have got that information, it's stored in your metadata, and you have digital methodologies by which you're capturing client information. I mean, we still capture a huge amount of information on pen and paper, don't we? Whereas when we're talking about those conversations now, we really should be capturing it digitally so that it's got that digital footprint. The second thing that comes to mind, again, is a parallel with the family publication, another podcast we did, whereby it was demonstrated to me that you can edit text messages now within 30 seconds or a minute of them having been sent. And this was in the context of divorce or family disputes, whereby you might perhaps send a rather derogatory message, make sure they've seen it, and then change it very quickly afterwards. And there's no audit trail for that at all. This is a similar kind of thing, isn't it, where something could have happened somewhere, but it could have been changed after the date.
Yeah, absolutely. And I think that's going to be something that we're really going to have to grapple with. I think it's probably incredibly similar to family disputes. While they're not the same legal issues, perhaps, but they are, the way they're dealt with. There are a lot of similarities between kind of our area and family law.
It's been a bit of a whistle-stop tour through this particular case, but I think what comes out of this is absolutely fascinating and some really challenging questions for the profession going forward. One of the big lessons that we ought to take from this, of course, is that the costs, which were somewhere in the region of £2 million, makes this kind of litigation incredibly expensive, incredibly prohibitive. We have to find better ways to resolve these in the future as well, don't we?
Yeah, we absolutely do. And I think in our defence, if you like, this was a case where there was a mediation fairly early on. So steps really were taken to try and resolve it without formal court proceedings. Unfortunately, it didn't result in a settlement. I think partly because the tax issues in this case were incredibly complex, and so there was a lot of moving parts, if you like, that made it quite difficult to kind of arrive at a mechanism that would work, that everyone could get comfortable with. But I think also later on we did try to reach an agreement as to a kind of more formal alternative dispute resolution process. So we made proposals for an FDR at one point, which again, unfortunately, we couldn't agree. But I think Bernadette and I would both agree that mediation and other forms of alternative dispute resolution are absolutely kind of at the forefront of our minds when we're advising our clients. And as you say, David, they can be an incredibly good way of limiting those costs, which can become hugely disproportionate and, like you say, prohibitive to a lot of people. Not everyone can afford to run this type of litigation.
I agree with Kate entirely. I think any kind of alternative dispute resolution has got to be embraced by all of the practitioners involved in each and every case. A trial in the court should be the sort of place of last resort, and not just because of the cost, but also the emotional toll it takes on those that have to give evidence and lay out for all to see and all to comment on their personal family history. It can't be understated. We will all have had those clients who turn up and it's their very first meeting and all they say to you is, I just want my day in court. And every practitioner worth their salt will immediately say, no, you don't. You think you do, but you don't. And it's not to say there's not a place for it, but it's not for the faint-hearted, and it's not to be encouraged. Litigation in this sphere should be approached much as it is in the family context, with a view to trying to find a solution rather than trying to score every single point that can possibly be taken and career towards a trial with no regard to the feelings and the emotions of the parties involved and all the costs. So yes, I couldn't be a bigger fan of mediation and all other forms of dispute resolution whenever possible. But as Kate says, sadly, not in this case, despite everybody's best efforts.
Words definitely to be heeded, and I'm very, very grateful to you both for sharing your insights, sharing your knowledge on the topic and the subject as well. So thank you so much for joining the podcast. Thank you, Bernadette.
Thank you very much for having us. It's been an absolute pleasure.
Thank you, Kate.
Thank you.
The Today's Wills and Probate podcast is available on your preferred podcast provider. It's also available on todayswillsandprobate.co.uk. My thanks to Bernadette and to Kate. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.